The Second Circuit Federal Appeals Court did not overturn former Assembly Speaker Sheldon Silver's conviction due to a lack of evidence. No. The court takes issue with the jury instructions, saying they conflicted with the U.S. Supreme Court overturning the fraud conviction of another former lawmaker in another state entirely, Virginia, and another party, by the way. He's a Republican. Attorney Paul DerOhannesian is joining me now to talk more about the Silver case. Thank you so much for being here.
Good to see you, Liz.
So I think that's actually maybe the crux of all of this, is that it wasn't for lack of evidence, which must drive U.S. Attorney or former U.S. Attorney Preet, who brought this case kind of mad. He has been tweeting about it. But the fact that the jury was not told of the narrower parameters as established by the U.S. Supreme Court in the McDonald case.
There's two parts to this case and decision. The first part involved whether there's sufficient evidence to justify the charges, and Silver lost that part of the case. And the reason that's important, if he had won that, that would be the end of the case. He couldn't be tried again because there is insufficient evidence. So that's important from a prosecutor's point of view. They have the opportunity, the case is saved. It also tells the defendant, look, if the prosecution can prove this again, these facts, there's enough here for a jury to convict. That's an important part of the decision that the prosecution won.
Well, there's enough there, but does it fit the definition as established by the U.S. Supreme Court?
And that's the concern the court had. Given what the Supreme Court has said involving what's official conduct, which we can talk about, we're concerned that the definition the judge gave made it so broad that they could have convicted for actions which were not illegal. Since we can't be sure of that, looking at this transcript, this defendant should get a new trial and get the right law given to the jury.
So, okay, and again, you know, there's a lot going on here, but the case basically, there was no real smoking gun. In other words, there was no one saying in email, in testimony, I am giving you X in return for Y. In other words, you're giving me state money for mesothelioma research because I'm a cancer doctor, and in return, I am directing my patients to bring their cases to the law firm where you're of counsel, and then everybody gets rich. The doctor, I think there was an understanding on one individual's part, but there was never formal agreement, and so there seems to be a lack of a connection there.
That was Silver's argument on sufficiency. But they said, well, the jury could still find something wrong there. The problem is, what were the official acts he did? Was it passing a resolution in the assembly? And they're saying that is something that happens all the time in the assembly.
Right.
That's a very routine thing to do. So are you criminalizing what would be a routine act? Is there anything criminal given for the passage of a resolution in the assembly? In fact, they have footnotes citing all the various different resolutions that had been approved. The problem the Supreme Court said is prosecutors have been using a definition that included all sorts of routine activities, almost anything a legislator did, as being an official action. And they said, no, it requires more. It has to be something for which you are inducing someone to act, whether it's a government agency, an organization. For example, in the McDonald case, setting up a meeting with constituents. In the Silver case, meeting with people who were contributing to your campaign. Legislators do that all the time. We make that the possibility of criminal conduct, that's the concern.
But the directing of state money that over which you have pretty much sole jurisdiction to do with what you will, given to an individual who then can subsequently enrich you personally, is that not sufficient?
That could be sufficient. The problem is, how do you know in this case whether the jury used that conduct or maybe something that wasn't illegal, like a meeting? And again, they're saying there's sufficient evidence here. That's why the first part of the decision shouldn't be overlooked also. There's sufficient evidence here to find the quid pro quo they're saying, but we want the jury to know what it is they have to look at, that they can't look at just routine meetings. Because if 6 jurors found that the meeting with certain lobbyists was the official action, 6 people found some other passage of legislation was the official action, that's not agreeing on one item. The jury should be told, you have to find certain things.
Well, what is the likelihood, though, that the case gets retried? I mean, as I brought up, Preet was the guy who brought the case. He was fired in pretty high public fashion, and he was upset about it after getting assurances from the president, so he's no longer there. It's his former deputy who's now acting, who says he'll retry, but all of the players are sort of shifted around now.
Still, it is the U.S. Attorney's already announced that they're going to retry it. Sometimes they take time. In the McDonald case, for example, they took their time and decided not to retry it because they didn't feel comfortable with the new law and the facts of that case. Here, the acting U.S. Attorney has said he will try it, but there's going to be a new U.S. Attorney in the Southern District.
Right,
He
at
or
some point.
she could come up with a different decision. So we don't know whether that is their final position or not. And you're right to say we really don't know whether it'll be a retrial or whether the parties will re-examine their positions and come to a resolution in this
Well,
case.
and also this part kind of blows my mind. I mean, we're talking about almost $5 million that that Silver was convicted and now has been not exonerated but overturned of ill-gotten gains. And then subsequently there was a fine that was close to $2 million that he was ordered to pay. He was facing a 12-year prison sentence. All of that is wiped away. He gets that money back.
Because he's in the same position as he was before trial started, presumed innocent, and that's very important.
Wow. Also, yesterday, perhaps Dean Skelos, the former Senate Majority Leader, who also was convicted on corruption charges in a completely different case, was feeling maybe less hopeful about his appeal. His attorneys making a similar argument to the Silver attorneys based on the McDonald case and the U.S. Supreme Court decision. But the Skelos case, if I remember correctly, was a lot stronger because of the wiretapping evidence.
It depends how a court views it. That's going to be the issue. We know that there was a mistake made in the Skelos case. The question will be whether they feel that mistake was of such dimension that they can't be sure the jury would come back with the guilty verdict.
The mistake in so much as not read to the jury.
That's right.
Okay,
Same
the decision
judge,
in McDonald.
and
Right.
again, the judge herself was concerned enough about this to say, I'm going to leave these defendants out, not have them go to jail, because I think there's a serious legal question here that another court should answer. There are certain questions that require appeals courts to answer that lawyers can't answer and trial judges can't answer.
But as a legal expert with so many years of experience, can you say that one case was stronger than the other?
I can't say that. I don't think you can say that, because I think the dynamics of both of those cases were such that if you had a retrial, I think anything can happen. We've seen that in retrials sometimes, that additional piece of information. And what the decision does is instructs both sides what their strengths and weaknesses are. That can lead you to do a couple things. You may want to resolve the case, or you say, look, this idea of passing resolutions is so routine, the court says. We're concerned about that. Maybe that's where you should focus your energy and show that so much of what happened was routine behavior of what they do in the Assembly or Senate.
So also, the Skelos appeal has been heard, and so that decision could be coming down any day. I mean, sort of in the dog days of July, nobody's really paying terribly much attention, and boom, here it is.
That's right. Now, there's no time limit. It's been argued. It's submitted. It could happen soon. We've had 2 this week involving people from the Assembly.
That's right.
And so it could be at any time.
But that conviction stood, Boylan Jr., if I remember correctly.
And again, his attorneys did not make the specific objection, which meant the appeals court said we're using a much more rigid standard to review this mistake.
Well, and also you brought this up before we came on the air. The judge in question is rather busy, actually.
That's right. And
so
the judge assigned this case also has 2 other trials involving the Percoco indictments, one scheduled in October, one scheduled in January. That could affect any scheduling of this case.
Will the McDonald decision by the U.S. Supreme Court impact that Buffalo Billion corruption trial?
I think there's a big debate in those cases about what an official act, official conduct is. I think it's still being debated. I think both of the decision of Boylan and this are going to be argued by the attorneys. I think there's something in it for everybody.
There will be, already has been, a call for state lawmakers now to finally get off the stick and pass additional ethics reform legislation. Now, you and I have had this conversation too. It's almost like Groundhog Day, Paul.
Yes.
It's really quite something. But anyway, doesn't federal law supersede anything at the state level that could be changed? Could it address this narrow definition?
Generally, yes. I mean, when we're talking about the definition of official action,
Correct, yeah.
That's under federal proceedings. The state could do its own definition of what's an official act and have its own set of corruption laws if it wishes. But generally, you don't see that in states. Generally, there's deference to federal authorities and the federal definitions of corruption.
Well, but also we saw how difficult it can be to bring a corruption case against a sitting state lawmaker. I mean, you might have thought, given the history, that it's actually rather easy because there was a string of convictions, mostly by Barrara, but not entirely. The state attorney general recently had a real failure in terms of Senator Rob Ortt and the effort that he tried to make there, and proving that Senator Ortt and his wife actually had gotten inappropriate benefits from their office.
That's right. And it shows you, again, the difficulty using certain of the state statutes, but also the requirements of making legal sufficiency for certain crimes. Because goes back to really your initial question, when you see an action taking place, is that evidence of corruption? Because usually there is not a direct, explicit agreement to link a specific act for money.
So we're out of time, but just to wrap things up, how happy should Shelley Silver be today?
I think he should be happy somewhat, because had he not won it all, he'd be going to prison for sure tomorrow. He has bought the opportunity to fight this case again and either get an acquittal or minimize what was a very lengthy sentence and very strict, harsh financial penalty. But he shouldn't go to bed saying, I have no problems, I have nothing to be worried about, because the court said, if they show these facts, there's enough there to convict.
Fascinating.